Welcome to Property 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. Today, we are talking about the fourth major question in this series, holding interests in property. In other videos, we discuss title and the various elements of deeds. In this video, we cover three types of deeds that you might find worth knowing. So the first type of deed is called a warranty deed. It protects buyers from all title defects. In other words, the seller has the responsibility for title flaws discovered after closing. As a buyer, this is a great type of deed. That said, the warranty protection is usually not generous. It's usually limited to the consideration the buyer gave for the land. So if you are buying land and you are provided with a warranty deed, you should certainly still get title insurance, which can help to deal with broader repercussions beyond just the price you paid. Second type of deed, a special warranty deed, that assures the buyer against grantor-created title defects. So not every title defect, and this particular type of deed is not used that often, but it's still important to note. The third kind of deed is a quitclaim deed, which has no covenants when it comes to title. A quitclaim deed makes the buyer take the risk that the title is not good. It conveys all the interest of the prior owner, but nothing more. As a buyer, you might be skeptical of a quitclaim deed. On the other hand, that's why we have title insurance, which helps to protect buyers' interests in title. The types of deed matters for certain warranties about title, but note here that there are other covenants that might be embedded in deeds. For example, the covenant of Sizin involves the grantor's promise that he owns the property he is purporting to convey. This relates to a principle that we call nemo dot. You cannot buy or obtain rights in something that are greater than the rights that the transferor had in that thing. In other videos, we discuss the different types of interests in property that might be conveyed. So sellers cannot convey fee simple when they only have a life estate. So that's the principle of nemo dot in a nutshell, and it relates to the covenant of Sizin. You might also see embedded in a deed a covenant against encumbrances. With this covenant, the seller promises that there are no mortgages, leases, liens, unpaid property taxes, or easements that encumber the property other than what is mentioned in the deed. Beyond these two examples of covenants, there are many other covenants and warranties that might be included in a deed that might complement or strengthen the covenants or protections given in the type of deed that a seller and buyer choose for the transaction. So with that, I'm going to leave it there, just covering briefly the type of deeds today. I'd love to hear from you, whether on Twitter or through my website, where you can sign up to my mailing list. See you next time.